Welcome, everybody. Thank you so much for joining us. We're really pleased to have you with us for this, the British Palestinian Committee's inaugural public event and the kickoff of our policy roundtable series under the title of Green-lighting Genocide, Britain and the War on Palestine. I'll do a quick bit of housekeeping first, just to say that we're live streaming this via Zoom. So hello to all the people at home, and I'm really hopeful they can hear us. We'll also be recording it so that the recording is available for afterwards. And as you can see, we've got a photographer here taking a few photographs. So if there's anybody who doesn't appear in photographs, please just come and let us know afterwards, and we'll make sure that that's taken care of. I should point out the fire exits are here at the rear of the room. I assume we just leave the building as quickly as possible in case of a fire. For those of you who might not be familiar with the British Palestinian Committee, we are an independent group of British Palestinian analysts, lawyers, human rights defenders, academics and others whose mission is to advocate for Palestinian rights by ensuring that British Palestinian voices are integral to public discourse and policy making towards Palestine here in the UK. The war on Palestine, as referenced in the title of this roundtable series, is not new. For more than 75 years, Israel has carried out a consistent military campaign of colonization and dispossession in Palestine. They have transformed a people with sovereign rights and a collective national life in their own land into a predominantly refugee people living in exile or under a brutal regime of military occupation and apartheid. Throughout this time, the State of Israel has relied upon the support, diplomatic, military, economic, ideological, of a handful of powerful states. Britain, often historically miscast as innocent bystander, hapless arbiter, or even tragic victim, has in fact been remarkably consistent in aiding and abetting Palestinian dispossession. Today, we see this in ongoing diplomatic support for Israel, in justifications for atrocities being committed, in the dehumanization of Palestinians in political rhetoric and media discourse, in efforts to undermine Palestinian attempts at accountability, the demonization of international solidarity, and of course, the active military assistance rendered to Israel as it commits the ethnic cleansing of Palestinians on a scale not witnessed since 1948. And this week's decision to cut funding to UNRWA to further deprive a population whose lives, whose families, whose communities, schools, hospitals are being decimated is a case in point. Britain's colonial debt is outstanding and ongoing, and it continues to grow through a political establishment whose unchecked support for the State of Israel has alienated political leaders from their professed support for universal principles, peace, justice, the rule of international law, and from the British public who reject, and alienated also from the British public who reject the hypocrisies of British policy and have taken to the streets on an unprecedented scale in recent months. I don't think it's an overstatement to say that we are at a historic low for British policy towards Palestine. And yet the cracks in the existing paradigm are beginning to show. It's now more urgent than ever as we step up efforts towards an immediate and permanent ceasefire that the voice of Palestinians is heard loudly and clearly in Westminster. Over the coming months, BPC will be hosting a series of panel discussions aiming to dissect and scrutinise the different dimensions of Britain's role in supporting Israel's genocidal war on Gaza. By convening experts, scholars and policymakers, we'll critically be examining Britain's legal, political, economic, military complicity in the emergency facing the Palestinian people today, while advancing practical policy approaches that support the protection of the Palestinian people, the realisation of their inalienable rights, and a just future for all. We look forward to having you join us for this series. Now, I am delighted to welcome a brilliant panel of legal scholars for this evening's event, which is co-sponsored by the SOAS Centre for Palestine Studies and the International State Crime Initiative, to guide us in a discussion of the International Court of Justice's landmark interim ruling announced last week. Dr. Nimer Sultany is a reader in public law at SOAS. He serves as the editor-in-chief of the Palestine Yearbook of International Law. He's published extensively on constitutional theory, comparative constitutionalism, and Israeli jurisprudence. His book, Law and Revolution, Legitimacy and Constitutionalism After the Arab Spring, won the 2018 Book Prize awarded by the International Society of Public Law, and the 2018 Peter Burke Prize for Outstanding Legal Scholarship from the Society of Legal Scholars. Next, we have Dr. Michelle Staggs Kelsall. She's a senior lecturer in law and co-director of the Centre for Human Rights Law at SOAS here in SOAS at the University of London. Michelle came to SOAS with over a decade of experience conducting applied research in West Africa and Southeast Asia, and working for the United Nations Office of the High Commissioner for Human Rights, where she obtained a respected reputation as an authoritative expert on human rights in the Asia-Pacific region. Dr. Kelsall is also the co-founder of Atlas, which is a global network of international lawyers committed to empowering, supporting, and connecting women pursuing careers in international law. And last but not least, we have Dr. Thomas MacManus, who is Senior Lecturer in State Crime and Acting Director of the International State Crime Initiative at Queen Mary University of London. He has a BA in Law and Accounting from the University of Limerick, an LLM with distinction in International Law from the University of Westminster, and a PhD in Law and Criminology from King's College, London. Dr. MacManus is admitted as an attorney at law in New York State and a solicitor in Ireland. He is editor-in-chief of the State Crime Journal and associate editor of the International Journal of Human Rights. Quite a lineup for you tonight. So Nimer, Michelle, Thomas, thank you so much for being here. We're going to start this evening by hearing some initial general remarks from each of our speakers, and they're going to give us a bit of analysis of the outcome of last week's ICJ ruling and its potential impact. And then we'll have a bit of a discussion among the panelists around implications for the UK specifically, and also recommendations as a result of the ruling. And then we'll have a bit of time at the end to open the floor to any questions before we wrap up. So I'm going to start by asking Michelle, if that's okay, to just give us a few opening remarks.
Absolutely. Thank you so much. And thank you everybody for joining us this evening. It's both a pleasure, a sad pleasure, and a privilege to be with you tonight for this discussion. I was asked to both comment on the outcome of the ruling and also to give you a bit of a preliminary background to the International Court of Justice, given my role as an international lawyer over many years, and how we could understand the ruling in the context of the ICJ's history. So, as many of you probably already know, the International Court of Justice was established in the aftermath of World War II, but was preceded by the Permanent Court of International Justice that was established in the aftermath of World War I by the League of Nations. Both courts over the course of the 20th century and continue to this day to be the highest courts of international justice. They sit at the apex of the United Nations, and their primary role, the role of the International Court of Justice, is to hear disputes between states and states parties on particular issues, to hold states accountable and hopefully bring justice. In this respect, I think, in addition to being a historic low for Palestine, we can say that we are experiencing a historic low for international law. The events of October 7 and the aftermath, in my view, caused many of us in the international legal community to undergo an existential crisis, because it seemed that numbers upon numbers of Western states, in particular, were justifying certain actions by the State of Israel by turning to using international law, but seemingly having very little in terms of an analysis of the extent to which the so-called claim of self-defense was actually tenable. I'm happy to speak more about this in the Q&A which follows, but to tell you a little bit about what the court is able to do in response to this situation, I wanted to give you a bit of background on the role of provisional measures and the manner in which provisional measures have been used historically in situations whereupon states are pleading with the court to act urgently in response to particular challenges. So provisional measures orders at the International Court of Justice can be read within a history of cases in which states require either a suspensory remedy to ensure that another state either performs or refrains from performing particular acts, or to secure particular aggravation, to prevent aggravation in a particular dispute. So in other words, either the court is being called upon to preserve a party's rights, in this instance, South Africa on behalf of the Palestinian people, or to protect a particular aspect of the nature of the proceedings. And there are four things which need to be met in order for provisional measures to be awarded. The first is that the party in question has to show the court has jurisdiction and that the claim itself is admissible. In this instance, South Africa was claiming that there was, in effect, a dispute between itself and Israel as regards to the fact that Israel itself was committing genocide. Secondly, there needs to be a link between the measures sought and requested and the rights underlying the main claim. So a causal link has to be shown between the measures that are being sought and the claims of the Palestinian people in this instance. South Africa obviously claimed that it wanted an immediate suspension in military operations against Gaza and to ensure that any military or irregular armed units which may be directed, supported, or influenced by Israel also refrain from military operations, because in South Africa's view, Israel was evincing acts which were capable of being construed as an intent to destroy in whole or in part the Palestinian people as a group, a specific ethnic group. In addition to this, in order for provisional measures to be awarded, the party in question must show the plausibility of the rights requested and the basis of those rights. And finally, that the risk of prejudice is irreparable. And that can be both a legal risk to the applicant in question or to the findings of the nature of the dispute. With regard to the ICJ's response in respect of each of these concerns and issues, I personally think that the court did as best it could under the circumstances to award what would be or would give effect at best and most possible the obligation to prevent genocide. The fact that it did not award a ceasefire, of course, is lamentable, but at the same time, under these particular conditions and the fact that Hamas was not represented in the courtroom, I think that was unlikely to have been awarded. Although the court's response was generalist, it did in effect do some important things in its decision, including calling Israel to account to the claim that Israel was above the possibility of genocide in light of the Holocaust. And we see this in relation to the way in which it framed the dispute and also the way in which it called upon General Assembly Resolution 96-1, the first resolution of the United Nations General Assembly, and invoked a Lemkinian moment in response to what Israel is doing in Gaza. I think the generality of its claims also gives rise to individual jurisdictions across the globe and lawyers within those jurisdictions to use the language of the court's judgment to their advantage, depending on their domestic laws. The wonderful thing about general language is that lawyers who are hopefully smart enough and creative enough to use that language can then, in effect, pursue different claims throughout domestic courts in various countries across the globe. So in general, I would say, from my perspective, it was possibly the best we could get in light of the circumstances. Thank you.
Yeah, thank you so much for organizing and for the attendance. So Michelle's introduction is really useful, so I'm going to jump to the question of what are the legal and political factors that make me think that this is a groundbreaking and momentous decision by the International Court of Justice. Unfortunately, some of the reactions from on the Palestinian side, we can call pessimists, and on the Israeli or pro-Israeli side, dismissive, they focused almost exclusively on the question of lack of ceasefire to the detriment of the historic importance of this decision. So I'm going to try to tell you why I think it's a historic decision and to what extent it's an advance in terms of both the general legal and political discourse about Palestine generally, but also with respect to the what's happening in Gaza in particular. So I think if there were to be a kind of a headline, as opposed to the one about the lack of ceasefire, to what the court did, the headline should be that there cannot be an Israeli exception to the duty to prevent genocide. That should have been the headline. Now, and I'm going to say why in terms of the question of the historic use of genocide. I will end with a little bit of mention of the question of ceasefire, but then I think Thomas will expand on this question. The first importance in terms of the legal discourse on Palestine. Those of us who have followed the legal debates, both in terms of international institutions and legal scholarship, the main frame, the main legal prism from which Palestine or the question of Palestine was viewed is IHL, International Humanitarian Law, the laws of armed conflict and the laws of occupation. In the last 3 years or so, there have been two advances taking from this discourse. The first was the question of apartheid. So the last 2 years or three, the description of Israeli treatment of the Palestinians as apartheid became mainstream human rights discourse. Now, there were different degrees of it. UN rapporteurs were limited by the question of 1967 mandate that they have. Human Rights Watch emphasized the 1967, but then Amnesty International, a year or so ago, said apartheid since 1948. So this is one of the reasons why Amnesty and other organizations were talking about apartheid finally, is because they understood the insufficiency and the incompleteness of the prism of international humanitarian law and the laws of occupation. One, because there is an attempt to understand the dynamics in terms of Israeli treatment with respect to different Palestinian groupings. So this requires a comprehensive narrative that international humanitarian law and the laws regulating conflicts, you know, the occasional outbreak of violence, or the ordinary laws on occupation does not necessarily capture. So if you read, for example, the Amnesty report, they say we need to have a comprehensive outlook that can describe what Israel is inflicting on the Palestinians inside Israel, what Israel is inflicting with respect to Palestinians who are refugees in Lebanon and Jordan and elsewhere in terms of denying them the right to nationality and return, what Israel is inflicting on the Palestinians in East Jerusalem, which is an annexed territory in the same way that Crimea is annexed, what Israel is inflicting on the West Bank and what is the Palestinians in the West Bank as well as in Gaza. So one of the mistakes usually that we fall into specifically in legal discourse and is replicated occasionally in political discourse is the compartmentalized view of these kind of communities. So instead of looking at the Israeli system of domination as one system with different manifestation vis-a-vis different Palestinian groups, we have been too accustomed to specifically because of the mechanisms in which the UN committees work. So they will treat the Palestinians inside Israel as, you know, citizens of Israel, and therefore the question of racial discrimination and the like as citizen. and then protected persons, those who are under the occupation, and then rarely the question of refugees, because it's treated through UNRWA, which is kind of welfare and education and health focus, and less on the political rights of statelessness. So with the concept of apartheid becoming a mainstream concept in human rights discourse, we finally are approaching a comprehensive narrative of what is Israel doing to the Palestinians. Now, some of us also push back against this by saying, well, we need colonialism. But the point is, this is the #1 advance in the last 3 years. Now, with the genocide case in the International Court of Justice, we have another advance, which is trying to show that what Israel has been doing to the Palestinians, specifically in Gaza since the 7th of October, is not only this discrete and multiplying singular violations of disparate rules of international law and of the laws of armed conflict. And one way to explain this, so if you look at the legal discourse, what legal scholars were writing before the South African application to the ICJ, they were writing about things like the proportionality of a particular attack in Jabalia. So there was no view of the whole. What is Israel doing now? What it has been doing since the 2nd of October? So why, how can we explain all of it? The evacuation orders, the ethnic cleansing, the displacement, the starvation as a method of warfare. How all of these violations can fit. And almost none of these legal scholars even mentioned the Israeli intent, meaning all these statements that have been coming out by Israeli officials, Israeli army generals, on TV, on Israeli TV, repeatedly. None of the legal scholars mentioned that. None of the mainstream media, I mean, rarely. There were like 2 articles, one in The Guardian, one New York Times, about the kind of genocidal rhetoric. So once the South Africa submitted the application, and once the, even further, once the court allowed this application to proceed and ordered provisional measures, you could see that the BBC and other news channels in this country show statements of genocidal nature to Israeli spokesmen when they were in the studios. And that was only because of this kind of. So that is a political, but also a legal advance for the following reason. In debates about genocide, it has been rare to describe what Israel has done to the Palestinians historically in terms of genocide. Many of you are familiar with ethnic cleansing as one of these dominant terms. There's like one article in the Journal of Genocide Research that says 1948 should be understood within the frame of genocide from over 10 years ago or so by Martin Shaw. Now, with everything that's happening and with the term of genocide, which many of us have been mentioning from first week of the onslaught in Gaza, but we were dismissed and dismissed and dismissed. And then even when South Africa submitted the application, it was also dismissed, like The Economist and New York Times and all these kind of mainstream platforms. So what will they say now with the International Court of Justice saying, no, actually, this is a serious claim. It's a claim that is plausible, and we need to hear it, and we need to go to the middle stage and examine it in full detail. So that gives backing to all of us who mentioned the question of the frame of genocide with respect to Gaza, but also it allows a historic reckoning, like a historic kind of revisionism, if you want, in which we look back. If this is genocide, why isn't 48 genocide? If this is, ethnic cleansing and starvation and the killing and the massacres, etc., in somewhat comparable, and there's like a lot of, including the South African oral presentation in the court in which they said this is an ongoing Nakba. So they mentioned the 1948. They mentioned this kind of context of decades-long apartheid, the brutality of the occupation, and the 16-year of siege on Gaza. So it reopens the question of 1948 also within the frame of genocide. And then in addition, The question of genocide is specifically sensitive because it was framed within the context of Europeans killing Europeans. And in the context of American discourse and Western discourse, it has been used politically only against those who are against America, the America's enemies, basically. So the Russians or the Chinese or what have you. And this is one of the first times in which the concept of genocide is used not only against Israel specifically, a state that, of course, was very dismissive of this charge in the beginning. The Americans were very dismissive. The Germans were very dismissive because of the historic context in which supposedly Israel was established. And then the court says no. Even the German judge in the separate opinion, Judge Nolte, who was sympathetic to many of Israel's argument, but joined on all the provisional measures, says, this is not an argument. This is not a legal argument to say, because we suffered genocide, we cannot inflict genocide on others. This is a legal question, and this is a factual question, and it can be examined in accordance with Israel's legal obligations. So that was shattered. This is a kind of a exceptionalism that Israel can claim because of the historic circumstances in which the concept of genocide was envisaged, was shattered, but also in terms of global South versus global North dynamics. Suddenly, you have a global South country, South Africa, with all the weight of its history, directing this accusation of genocide against a European colony in the Middle East, which is Israel. So that is kind of a flipping or a reversal of the ways in which the concept of genocide is used. It's an attack on the monopoly that has been claimed by the West, but also particularly Israel, in terms of the usage of genocide, and this is vital. Now, in terms of the question, the political, again, people should remember that there's a lot of disappointment that is shows a lot of short memory when it comes to what we experienced only a few weeks ago. When South Africa submitted the 84 pages of the claim that this is a genocide, enumerating all that Israel has been doing and all the statements that matched these actions, Palestinians, for the first time, in the public discourse, in the media discourse, in the international discourse about that followed 7th of October, for the first time, they had a voice. I was looking for different ways in which to describe what I think South Africa did by presenting this comprehensive narrative and also providing a context that is different than the one that was dominant in the media. And the best way I could think of it is the one that was provided by Diana Botto a couple of weeks ago, when she said, I felt seen. And I think many Palestinians have reacted in the same way. For the first time, being demonized, dehumanized for weeks and weeks to no end in all the platforms, excluded from voicing their own voices, and reprimanded for attempting to contextualize the outbreak of violence, because this violence is part of a structural condition in which this violence repeatedly every now and then, not only in the context of Gaza, but historically has appeared. So if you want to understand it, and if you really want to resolve it, you need to understand this repetitive structural colonial condition. And South Africa was the first time. I mean, I could write an infinite number of op-eds or blogs or TV interviews, but it would not have the same effect in which a weighty country like South Africa, invoking one of the gravest crimes possible in international law in the highest court of the land, and presenting 84 narrative that is read and taken seriously and listened to by everyone, and suddenly in the media landscape has changed. Suddenly there's a crack in the narrative about the war, in the Western propaganda about the war. And suddenly there's context. And suddenly the South African also in the oral hearing say, no, there's something called Nakba, there's something called apartheid, and there's something called 16 years of siege on Gaza. And you can't understand what has happened without understanding all of that. So that context, the invocation of context, is through this legal document, is through, now, admittedly, The court itself only focused on the immediate context. But the fact that they accepted this South African application and gave South Africa most of what it wanted in terms of provisional measures means it shows that the South African case was compelling, that it rejects the dismissal or dismissive tone by the Israelis. It made no mention at all of Israel's right to defense because, as the South African argued, it's irrelevant because you cannot invoke the right to self-defense, even if you had one, in order to justify genocide. You cannot, in the name of security, impose apartheid. So there are limits in terms of international law, even if you allegedly had the. So the question of context, the retrieval of context is also important in terms of the politics of it. And finally, in terms of the question of ceasefire. If you remember, in the 24th of November, there was a ceasefire for about a week between Hamas and Israel. And the achievements of the ceasefire were allowing humanitarian aid and kind of medical aid. Now, one of the problems, I think, with the language of ceasefire, it obscures two things. It obscures the gross asymmetry of power between the parties. This is not Russia versus Ukraine. Ukraine is supported by the whole gamut of Western arsenal. So these are two regular armies with fighting forces. No matter how the Israelis and the Western media exaggerates the Hamas military threat, it's not comparable to the Israeli, as we have seen, destructive, savage powers in terms of what they can inflict on the Palestinians. So this gross asymmetry of power is somewhat, I think, diluted when you talk about ceasefire as if you have two parties. And the whole difficulty, I think, from the beginning was that there was this talk about Hamas being this kind of external entity crossing a southern border and attacking the unsuspecting Israel. But again, this was the contribution of South Africa, as well as the final kind of provisional measures order by the court, is that South Africa insisted that this is a situation of occupation. It insisted that this is not an external border, and therefore the situation is the dynamics between the parties should be understood in that context. And at least one of the judges, the Chinese judge, in the separate opinion said the international community have a special responsibility when it comes to the ongoing denial of the right to self-determination of the Palestinians, even though it wasn't mentioned in the ruling itself. The second thing that the ceasefire language obscures, and more importantly, is as a matter of international law, you don't need a ceasefire for Israel to abide by its obligations. In 2018, there was a UN Security Council resolution that says you cannot use starvation and unlawful prevention of humanitarian aid as a method of warfare. So in 24th of November, when there was a ceasefire, the achievement was allowing humanitarian aid. But without a ceasefire, Israel is still obligated to allow humanitarian aid. Now, when it comes to the provisional measures that the court said, what the court said is that Israel has to allow effective and immediate humanitarian aid. Before that, it quoted UN officials who said, you cannot have effective and immediate aid with the ongoing onslaught, with the ongoing bombardment. So the only way to interpret that is to say Israel has to drastically scale down its military operations for effective and immediate humanitarian aid to be allowed. When the provisional measures say you need to be careful not to create conditions that are calculated to destroy the conditions of life or will lead to the physical destruction of a substantial part of the Palestinian people in Gaza, the only way to achieve that is by drastically scaling down the military operation. And the difficulty with the reactions of many is that when you focus on the lack of ceasefire, it becomes as if it's a license for Israel to continue as it has been doing. And this was the kind of Western narrative, and the Americans saying, well, the ruling is actually consistent with American foreign policy. Nonsense. Because the court already said that Israel's argument that is already allowing some humanitarian aid and taking some measures of that sort is insufficient and it's not convincing. So it cannot be that Israel or the lack of ceasefire order means that Israel can continue in the same way it did with respect to humanitarian aid. It has to allow effective and immediate, and that has to mean scaling down the, finally, in terms of the politics of the court. Look, we need to understand that ultimately courts are limited in terms of what they can do. And the main limitations is that in terms of their enforcement, they rely on others. So whether it's domestic courts or international courts, the enforcement relies on other forces outside the court. And I assume the court looked like the rest of us for 3 months or so at the international political system, the UN in particular, and its failure to order ceasefire. And the mechanism of enforcement of International Court of Justice rulings is through the UN Security Council. So I assume, I assume the judges thought that if we order a ceasefire, it will not be abided by, and that this way we will look weak. We will expose our weakness in the system. And again, we can speculate about why, but when you have 15 judges agreeing on a certain ruling, you can see why the ruling was somewhat thin in terms of the grounds it provided, and the maybe perhaps shorter list of provisional measures ordered. I will conclude by this. Look, those of us who have been critical of law and generally and international law in particular have always said the following: law and politics are intertwined. So even though politics shapes law and law is not autonomous from politics, it is still the case that law can be an element in a political struggle. It can shape politics. So the struggle since the ruling is how to take this ruling forward to advance the cause of the anti-war mobilization. How to take this ruling forward in order to expose further Israel as a rogue state, a state that has been treated by the West above law, above international law, and to focus on these positive elements, because we need to remember that even positive rulings are open to subversion, to violation, to setback. And the only way for these rulings to be capitalized on is on us, on organizing, on movement, on tomorrow having a stronger mobilization, anti-war mobilization, and to build on these rulings rather than to focus on what we didn't get, which many legal scholars didn't even expect it.
Thank you. Thank you very much. There's a lot to dig into there. It's really, yeah. I'm going to refrain for a minute so that we can have, because I'd like Tom to come in here if that's possible. And Tom, I know you wanted to pick up on the ceasefire question.
Yeah.
Also, then if you wanted to take us a little bit into some of the opportunities that the ruling creates, some of the questions around operationalizing some of the obligations, and even into the UK context as well, as you see fit, that'd be great.
Yeah, great, I will do. Thank you.
Thank you so much.
And thank you for inviting me, and thank you everyone for coming to listen and to hopefully engage with this after. When I was watching with everyone else, the results, the indication of interim measures, I thought it was the best that we could have hoped for, that we were going to get. I was quite surprised, actually. I thought the court went a bit further even than most were hoping. And then I realized there was a wave of disappointment, mainly on the ceasefire point. And I suppose there was a disconnect between the expectations of those of us who watched the court and people from the outside who maybe hadn't followed the court's work over the years. And I think the disappointment is correct. I think we should be in a permanent state of disappointment with international justice. I think that makes sense. But it wasn't really about what the court was ever going to say. It's about what we do with it. And that's something, it wasn't about what the court was going to do. It's what we do with what it said. And we can look at that. I want to go back a bit to, back a few years, we at Queen Mary and lots of people were seeing lots of reports coming out of Burma about a genocide happening against the Rohingya in Burma. And we were looking at these reports and they really matched up with genocides we'd seen in the past, the preliminary stages before the annihilation of the Rohingya people. And we wrote to the government and said, this looks like there's a risk, a serious risk. And we use that term serious risk. The treaty, the genocide treaty doesn't talk about how you prevent, but we have case law now. And the Bosnia case said if there's a serious risk of genocide, the prevention mechanisms from the treaty kicks in and all states have to do everything in their capacity to prevent the genocide. And we can come back and talk about the treaty. And so we wrote it was David Cameron at the time, and the response was, yes, it looks interesting, but we don't have enough information about what's going on the ground. The Burmese won't let us in. And we said, okay, that makes sense. And we applied to the government for funding, and they gave us funding to spend a year. We sent people into Burma, and they spent 3 or 4 months interviewing both victims of the atrocities and people who had carried it out, and put together a report that showed basically that all the stages of genocide had been followed, and we're looking at an ongoing genocide. Sent that into the government and said, okay, now you're on serious risk. And they said, no, we're not actually, that only a court of law can make a determination if genocide is happening. And where does that leave us? That leaves us with some kind of case at the ICC, maybe, which we know takes 10, 20, 30 years. And how are we going to prevent what's happening now if that happened? Now, nobody had thought about going to the ICJ at the time, I don't think, and the Gambia did that later on. And when we met with the government, we talked with them about the serious risk. And years later, I did a Freedom of Information request to find out where those conversations went. And they went absolutely nowhere. They just let someone meet with us. And that was the end of the story. So they had no even mechanism for putting in place dealing with this serious risk. Then the Gambia took Burma to court for a breach of the convention. And the ICJ is different from the ICC. The ICC focuses on the individual criminal responsibility. So it finds people who we know have committed genocide and it punishes them years later, which doesn't help with prevention at all. The ICJ is more of I think of it like a contract law kind of court. You have a contract, you have a convention between two countries, and you show that there's a dispute. Now, the dispute was quite simple. South Africa was saying, you're committing genocide. Israel was saying, no, we're not. And that was enough. That was enough for the court to say they'd seen in multilateral statements that South Africa had accused, or they haven't even accused, they just said that there's a genocide happening, we think, inside Israel, Palestine. And Israel had kind of poo-pooed that idea and said, no, there's absolutely no way. And that was enough to form a dispute. And then we have jurisdiction, and then, well, some jurisdiction, and then we can go to the court. Now, South Africa's case was quite brilliant in that it had to show 2 things to show there was a plausible case. One, that there was acts of genocide on the ground. And to do that, they only used, I think, exclusively UN agencies and UN bodies. They're speaking to the ICJ. It's the judicial body of the UN. So that was quite a clever way of doing it. We're talking to you using your own personnel, basically. And then to show intent, which is always the most difficult part. If you talk to any lawyers who are trying to prosecute genocide, it's so difficult to show intent. No one's going to go out and say that these people are animals and we want to destroy them all and then actually do it. It just never happens. It shows a kind of an unfathomable confidence and an arrogance to be doing that publicly when you're attacking a civilian population at the same time. And so just showing pronouncements of high level of governments that were publicly available to everyone and putting those 2 things together, the court couldn't not say that there was a plausible case of genocide. But it does lead us back to the old problem of we still don't have a determination that genocide has happened. We don't have an international court that said genocide is or has happened inside Israel, Palestine. And so we still, even though we have lots to work with, we still have to bear that in mind. If you talk to a UN lawyer, they're going to say, they're going to continue to talk about risk, possible alleged genocides happening. So we still haven't got to where we need to go from that point of view. And maybe that's for punishment and it's for something else later down the line. But when we come back to prevention, the serious risk, we no longer have to rely on NGOs and people on the ground and newspapers and UN agencies. We now have an international court that has said, yes, there is a serious risk. They didn't use those terms, but they said there's a serious risk. There's a plausible case of genocide on the ground, therefore there's a serious risk. And therefore the prevention from the Genocide Convention. No other treaty has this kind of prevention mechanism. War crimes has something to a lesser extent, but we're still not sure how that works. Crimes against humanity doesn't have it at all. Now we have a situation where all countries in the world have to do a due diligence and work out, have we been enabling what's going on in Israel? And if we have to somehow stop that. And also, what capacity do we have to prevent it? Can we table resolutions? Can we, at the UN Security Council, can we do it in the General Assembly? Can we join the ICJ case? Maybe that is something we can do to express that we're trying to do something for prevention. And ultimately, I mean, this is an extreme example, but could we get a multilateral armed force together in order to go in and stop what's happening? I mean, that's, you know, we're talking about serious situation there. And I mean, when I mean a serious situation, I mean a serious legal situation. We have a serious situation on the ground that probably would recommend such action. But to get states to move along the diplomatic ratcheting up of pressure to that end of the scale, I think we're a good bit off that yet. So there still should be disappointment because we've no determination, but there's so much we can do with the fact that there's now a serious risk, that has now triggered the Genocide Convention. It's a convention, it doesn't matter if you've signed it or not, it's completely applies to all states in the world. The other thing they didn't do where the disappointment is order a ceasefire. In international humanitarian law, there is no such thing as a ceasefire as such. The word isn't in the legal lexicon. That is of no interest to people on the ground in Gaza, what we call it. They were looking for Israel to stop what they're doing. And I think actually that's what the court said. It did say stop what you're doing. It said there's a plausible case of genocidal acts with genocidal intent. You're doing it, and you now have to stop doing what you're doing. So in a way, they ordered a ceasefire. Some of the arguments being used why they didn't order a ceasefire is that it would interfere with their inherent right to self-defense. And I agree with what's been said before that it's really not clear and it probably isn't existing that there is an inherent right to self-defense in this situation because we're not looking at an attack from outside the state or another state. Self-defense is about states' interactions with each other. Now, you wouldn't be able to argue that Israel doesn't have a right to defend its citizens. That's a different thing, but if you couch it as self-defense, you're conflating with it as this international law inherent right to self-defense, which is something else completely. And some are arguing that the court didn't order a ceasefire because it would interfere with that right. That's not a good argument, and it's only being used to try and bolster that idea that there's inherent self-defense. The other argument I hear is that, well, they ordered it in Ukraine, Russia, so why couldn't they have ordered it here? That case actually was the opposite. Ukraine were arguing, Russia were arguing that they were intervening in Ukraine because of the Genocide Convention. They were going in because they have a responsibility to prevent genocide. The same responsibilities we're talking about now that we're trying to operationalize. And they said nobody would join us in a multilateral invasion, so we had to do it on our own. Again, the court probably wouldn't agree even if there was, but that's you know, legal thinking down the line that's not of interest. So they were saying to the court, the International Court of Justice was saying to Russia, there's absolutely no evidence of a genocide happening inside Ukraine, so you must pull your troops out if that's the justification you're using. That justification isn't good enough, and therefore you must stop doing what you're doing. So it's almost the opposite of what we're looking at here. And the court is kind of strategic away in as well for not, if even they were thinking about doing it. If they had ordered a cessation of hostilities, I think it would have been so much easier to dismiss the case by the US and the UK and the Israeli state, saying, well, then you're interfering with our right to defend our citizens. You're saying we have to drop our arms, and opens ourselves up to attack. And I think the court would have lost legitimacy if they had tried to do that, even though I don't think it was even within the realms of something they could offer, which raises the question of why South Africa asked for it in the first place. That's something I don't know, and I'd like to know more about their thinking along those lines. Maybe they just thought, because it had happened in another case, that there'll be some way the court, it was expressing to the court the extent of what they wanted them to do, and maybe that's what it was. And the court could, of course, made up its own provisional measures, which it did, to do with humanitarian aid and restoring basic services. So the value, though, is that we now have this trigger. The Genocide Convention has been triggered in this situation. And everyone, all states in the world, now have to do that, have to get involved to see whether they're completely disconnected or heavily involved. They still have to look at all their states, all the companies which operate inside their states, any way they can influence the situation. They now have to look at how they do that. And I think maybe that's why we're seeing talk of recognizing Palestine by the UK, because if we look back, the UK can say, well, actually, we did start, as soon as the case happened, we did start looking into our prevention policies. So you have to look out for some kind of faux action on the part of the state that they can show afterwards. If we do get a determination of genocide, all the states that didn't do anything to prevent, or didn't do everything in their capacity to prevent, can then be sued themselves. And that's what they're thinking about now. That's what they're thinking about. If we never get a determination of genocide, then they don't have to worry. But that's a risk calculation that the states are going to have to pay. And we're going to have to wait 4 or 5 years before the ICJ make any determination of this. But that case itself, the things that we're going to see that come out in that case, and we saw that South Africa are not sticking to the current context. They're looking at it in the wider context, and they're going to bring that out as well. And we're going to have the whole world watching what's happening, but that's for down the line. That's no use to us now with what's going on in Gaza. And the international court's role is kind of over when it comes to looking at the situation on the ground now. It's now up to states and civil society to use the court as a platform, to use this trigger as a platform to do something. And then maybe we can talk about what that would be.
Thank you all so much. That's, yeah, incredibly rich interventions. I wish we had like 3 hours to talk about it. I'm going to pick up, just before we open to the floor, I'm going to pick up on something that links into what you just finished saying, Tom. And Michelle, you talked about how it was general language can be really useful in the international court of justice, because then courts in domestic cases or in other states can use it domestically and work with it more. So I'm wondering what kinds of things, and this kind of speaks to the sorts of things like in the UK, for example, that the British government could be doing. We're not saying that they would, but what kinds of things can states do based on this kind of as government as position? And we can go into even sort of civil society and broaden.
Yeah, I mean, I think there's a number of things that come out of the decisions that can be utilized by those currently in the UK and in other jurisdictions. I think what's been really damning and galling has been the response to the allegations of Hamas operatives being in UNRWA, and the manner in which a multiplicity of states have actually responded to that by withdrawing funds from that agency. And personally, I think the ICJ decision puts those states on notice that they're actually failing to prevent genocide. They're failing in their obligation to prevent by that very action. And they're also potentially complicit in genocide by removing those funds from one of the key UN agencies, obviously assisting in relief efforts in Gaza and amongst the refugee population. I think what's really damning about what's happened is there's been so little attempt to assess the allegations, the plausibility of the allegations prior to doing so. The EU, I think, is the only regional body that they've said that they will assess the allegations prior to any action in this regard. So I think one of the first things that we can do is try to hold our governments to account to push for funding to be reinstated and to bring claims as to the extent to which that in of itself it could be alleged as complicity in this respect. In terms of enforcement of the ICJ rulings, just to give a little bit of colour to what Nimer was telling us, prior to 2001, the binding nature of provisional measures decisions was in effect very controversial. But with a case in 2001 at the ICJ, the Legrand case, which was a case in which a German national was going to be executed in the United States in the state of Virginia, and Germany brought proceedings to the ICJ to stay that execution and was awarded provisional measures in that respect. The court has since taken a number of measures to ensure that it can enforce its measures, one of which is the establishment of a judicial committee of oversight for those measures. So when it requests that Israel in reports with respect to how it's in effect being true to the measures that are now being enforced, they will have a committee, therefore, assessing the extent to which Israel is engaged in such measures and how it's playing them out. Now, what this means is that there's a mechanism already for this documenting and reporting, which also lawyers who have access to those reports can utilize to then go to their states and say, and other various advocacy agencies say, you know, to what extent are you enabling arms and ammunition to be given to Israel? Israel is clearly not engaged in preventing a genocide from occurring. We need further action from you as our state officials in response to this. Allegations can be brought through various domestic courts in this regard as well. With respect to universal jurisdiction for prosecution, I don't know if you want me to go into that now, or
Yeah,
the guys want to.
or if anyone wants to jump in,
They
you're
had a-
welcome. Universal jurisdiction.
I mean, it's criminalized by the International Criminal Courts Act 2001, genocide in the UK. But there are a number of blocks to the possibility of universal jurisdiction being enforceable in this country, one of which, of course, is the fact that the law limits prosecutions for most international crimes to suspects who are UK residents or citizens. Another of which is that it's inconsistent about the temporal nature of the jurisdiction required. So you can't prosecute crimes. I mean, it wouldn't be an issue, I think, in this instance, because the crimes are ongoing. So, but there may be different difficulties with respect to citizens' arrest. I don't know if you want to comment on that.
I mean, you would have to. Well, first, the International Criminal Courts Act replaced I can't remember what it was called, but there was a Genocide Treaty Act there beforehand. And what we lost, though, when they replaced it, so the Genocide Treaty Act was to incorporate the Genocide Treaty into UK law. And then when the ICC came along, they said, well, all the crimes are in the ICC Act, so we'll just bring it in. And that's right, that's true, but we don't have the prevention part of the treaty now anymore. So they've actually taken that away.
Yeah.
Had that still been there, you could have prosecuted people in the UK for failing to prevent genocide. We can no longer do that. So I don't know if that was strategically done or if someone forgot on the day to bring through the prevention part. And so we've lost the ability now under UK law. It may be possible using customary international law, but it's much more difficult. We lost when they switched that switcheroo. We've lost the prevention, the ability to prosecute people for failing to prevent in the UK, and that needs to be brought back. So that's one thing we need to look at. Definitely, if people are thinking about policy, we need to bring that back. Otherwise, now that we have a plausible case on the ground, you could show that to the High Court here and say there's a prima facie case. On the face of it, genocide is happening. So anyone that's involved in it, that comes and lands on UK territory, you can go and get a bench warrant. Anyone can do this, can go and get a bench warrant, and then ask the police to arrest them. Probably is easier, but there are situations the police have no more powers for arrest than any of the rest of us in the UK for crimes that are ongoing at the moment. I don't recommend it, especially, you know, at any time, never mind in this context, I don't recommend it.
We're in.
But since someone tried to do that to the Israeli foreign minister and the police actually tipped them off in Heathrow and they took off again before the arrest, since that happened, it now has to go through the Attorney General. So there's an extra layer of politicization into that now. But they have to give reasons as to why they're not doing it. And that would be an interesting exercise in and of itself. Why aren't you allowing for arrest when there's a prima facie case of genocide going on? And that's not just the UK, any state any state does have your universal jurisdiction, but it's the question of what mechanisms they have to enact it, can do that. So there is a possibility there of arresting anyone from the Israeli government that arrives here. And I think lawyers should be putting together, because you need that package ready to go on the day when they land, because often you don't know when they're coming. So I think lawyers should be putting together a package ready to bring to the High Court when that happens.
So yeah, if I can add a few kind of brief additional factors to it. So one thing is important to remember with respect to the provisional measures. This is now an ongoing case, meaning there can be an invocation of other provisional measures in the future. And one occasion for doing that will be, one of the provisional measures was within 1 month, Israel has to submit a report, and then South Africa will reply to it. So if the report is judged as very insufficient and not serious, there can be an attempt on the part of South Africa to ask for much harsher or much more immediate provisional measures. So we'll wait and see. The other issue in terms of how, how this can cascade into different kind of elements and moments of pressure and mobilization. The boycott, divestment, and sanctions movement can now have the backing of this ruling. I mean, what better than the risk of genocide to motivate people to act? And now there is in the parliament of this country a shameful bill that is trying to prevent local councils and people of conscience in this country from divesting and basically injustice. So will the British Parliament continue with this shameless and shameful bill? That's a question. We saw from the beginning of the war all these EU officials, UK officials, American officials running for photo ops with the Yoav Gallant, the Minister of Defense, with Yitzhak Herzog, the president. Now these people are in the record of the court as examples of potentially genocidal language. Will they continue to shake hands with these guys? Will continue to meet with these guys as they met Herzog in Davos recently before the court ruling? So these are questions that all these countries now. Will the UK, the US, and Germany continue to send arms to Israel now after this ruling, when there's a risk of genocide and therefore the risk of them being complicit in genocide? So all these questions now need to be put to all these. Now, of course, other countries in the world can also intervene in this case. We heard the shameless and shameful Germans say even before the ruling that they were going to intervene on behalf of Israel in support of Israel's. And that obviously seemed to be like an attempt to influence the court's ruling. But what was beautiful about that is that Namibia immediately called out the Germans and again showed us that the concept of genocide has a history that precedes the Genocide Convention, which is colonialism. So why is it colonial genocide, or whatever you want to call it, mass slaughter, has been excluded from this concept of genocide? So all these questions, I think, are, the question of Zionism. So if Zionism, has been successful since the 7th of October in mobilizing Jewish public opinion around the world by claiming that this is an attack on Jews. But if the only concept of Israeli security is the elimination of Palestinians, and if Zionism ends with an eliminationist logic, then obviously that should increase anti-Zionist mobilization and solidarity with the Palestinians against Zionism as the victims of Zionism.
That's really well ended, actually, in terms of the sort of recommendation question. I think it takes us really nicely into. I've got about 20 minutes left, and so I'd really like to open the floor up and allow any of you to sort of ask questions. I'll take a few at a time, I think, and then if that's all right, and then we'll answer a few at a time. So I can see some hands up. So let's start here, and then we'll go across the room. So, yeah, sorry, watch out.
You mentioned the Nakba, and then it was just why wasn't a question of Nakba pulled them to the ICJ over the past 75 years? No, we haven't tried it. No other country has tried to bring the Nakba to the ICJ. Why was that?
I'll take two more, and then we'll come and do them together. So I'll go across the room. So I'll go here, and then. Sorry, and then Amjad, and then we'll come to the next round. I'll get these two. Sorry.
So yeah, so my question is two parts. One is from a procedural and an implications perspective, we've had the legal advisory opinion on the wall, which was in 2004. There's this ICJ ruling on genocide, and you have the current case that's going to be ongoing on the legal consequences of policies and procedures, practices of the Israeli government in the occupied territories. What is the interplay? What is the implication of all three of those different cases that have taken place in the general landscape of legal consideration of the question of Palestine? And then subsequently considering, and I know you've talked about this a little bit, what are the procedural elements and what are the binding implications of this on domestic states and local states? And how can people therefore take action for those specific things? I know it's been mentioned a little bit, but going into a little bit more detail.
Thank you. And I'll take one more from Amjad, and then I'll come across there for the next round.
I'm sure you might have been following a case that was filed in California against Biden, Blinken, and Austin by the Center for Constitutional Rights, which the judge seemed very supportive of the claims, basically charging them with genocide, but ultimately failed just a few days ago, or the judge kind of dismissed it. I'm curious about your takeaways from that case and the lessons that portends for the United States or other places. And just to kind of, and to follow up on this, I'm curious also if there's a more complex or nuanced record by the United States in regards to ICJ rulings. I imagine many have been kind of politically ignored, but I'm curious if there's more nuances in that record that could tell us also where this might lead in the future.
So we've got one around genocide and why that case has not been brought before. Question around procedural and the different types of cases of the ICJ and how they play. It's a bit more detail on the nature of what states can do, and the question around the US and the ICJ rulings, and if you're aware of this case that's recently been put. Any takeaways on that? Actually, would like to go. And we'll try and spend about 5 minutes or so on this, so I can take one more other questions after. Feel free to pick up in any order and on whichever ones you want to there, Michelle.
I'll probably speak to the second question more than the first, given in light of, I think it's probably better for Nimer to speak on the Nakba than myself. In terms of the implications of the three decisions before the ICJ and how they then have binding implications on domestic states. I mean, as a matter of law, the rulings of the International Court of Justice, the judgments, are binding on states. However, that being said, the ones that you're actually referring to were, one was an advisory opinion for the General Assembly. So as such, it was answering in particular response to the GA. I think what's come out of these three decisions and what continues to be an important implication of them that can be pursued is the right to self-determination, which is as seen as a right under international law that has basically the status of a peremptory norm. So in other words, it's a right that should be able to be enforced. And what's interesting, I think, now in the political debates in the UK and what could be further utilised would be the extent to which that right as a substantive right and a procedural right should be afforded to the Palestinian people, and the ways in which recent assessments made by Cameron and others around this idea of a two-state solution, which, as I know many of us think, including myself, is mere rhetoric, but actually holding them to account to that in light of the ICJ opinions on the same, and enforcing that right, and thinking through, in so doing, bringing to the courts the colonial history that implies, and the manner in which this is a moment in which we can have a reckoning with that.
Can I just add on top of that, on top of the legal implications of those cases, I think there's an implication in the impunity we've seen from all the Security Council resolutions, General Assembly resolutions, court cases, advisory opinions that have been completely ignored by Israel over the years. When we get to the question of how a genocide has happened, or how it has been happening for so long, I think that will feed into that question and help answer that question, and the fingers will be pointed at the Security Council and veto holders and things about their culpability and their role in enabling genocide for so long. I think so. That's beyond the legal kind of scope, but I think the impunity that we've seen is part of why we are where we are today, and I think that's where that will become valuable in the analysis.
So in terms of the question of which claims can be brought before the ICJ, the party needs to be a state. So there are, even the Palestinian Authority now is, its status in international law is not necessarily recognized as a state, and that's why there was a lot of difficulty and reticence in the ICC, as a Court context, of allowing claims by the PA, but the same kind of obstacle, and it's the same reason why the PA, it wasn't the PA who even if it wanted politically to do it, they wouldn't be able to do what South Africa did, submit this kind of claim with respect even to Gaza, not only with respect to a historic claim. There will be a question of, Michelle and Thomas might know more about this than me. If certain actions of genocide were committed before the Genocide Convention, whether they will be applicable or can be claimed in the court. The question of the wall, and then the ICJ and genocide, and then the ICJ now on the question of the illegality of the occupation. Now, one of the interesting things about the 2004 decision is that it said that the violation of self-determination is a violation of the Palestinian right to self-determination, a violation of a very important right in international law. And there is an obligation on all states to basically aid the Palestinians, or at least not to be complicit in Israel's attempt to undermine the Palestinian right to self-determination. In that case, the construction of the wall, which was understood by the court as a form of annexation, as well as a violation of the Palestinian right to self-determination. And all states, the court said, has an obligation to not to aid Israel or to try to obstruct Israel from the construction of the wall, and therefore the violation of the right to self-determination. It was nice that in the current ruling, Judge Shaw, the Chinese judge in the ICJ on genocide, reminded the readers with that particular obligation from in that ICJ ruling. And he said, because of that ongoing violation of self-determination, we have, in this case of genocide, we have a special responsibility to protect the Palestinians or to prevent the commitment of these actions. Now, one shortcoming of the ICJ ruling on the wall, the advisory opinion on the wall, is that it was completely within the 242 two-state framework. The question of colonialism was not in the decision. Question of apartheid was not in the decision. Since then, as I indicated in the opening remarks, international legal discourse have moved. Now, one of the important decisions by the ICJ was with respect to Chagos, the Chagos Islands, and the fact that the UK has to decolonize. Now, in that particular case, the declaration against colonialism in 1960 was invoked. The question of decolonization was invoked explicitly, unlike the case in Palestine. So the question for me would be, and I suspect that will be presented by the team, because some of the lawyers who represented Chagos are representing Palestine in the February hearing. There will be a mention of the question of colonialism. There will be a mention of the question of decolonization, and I hope so. But I think it may have been that when the court decided, the Genocide Convention had in mind the case that they already had on the dock with respect to how do we describe this kind of prolonged occupation that Israel has been inflicting on the Palestinians. So colonialism can be one answer, apartheid can be another answer, and that will be for me another test whether international law can adequately address the question of Palestine, even more so than the case of the wall in 2004. But in all cases, the other kind of test, and this is why Palestine is a litmus test for the international law, is whether any of this will be enforced. With respect to the advisory opinion, they would say, well, it's an advisory opinion, and it's not necessarily compelling, like a binding. But with respect to the provisional measures, this is an order, so it's supposed to be compelling. But again, the enforcement agency is outside the will of the court, and then it depends how brazen the UK, the US, and Germany, and the rest of it. And there is a chance that the whole international legal system will crumble because of this brazen attitude.
Did anyone want to briefly comment on the US relationship with the ICJ, or?
So I haven't read the ruling by the court in the US, so I can't really comment on it. But it was great that the judge, despite the fact, so the judge obviously could have dismissed the case from the beginning without hearing testimonies. Instead, the judge decided to hear testimonies, at least like one day of testimonies. So that was, very interesting decision and platforming of Palestinian voices and attempt, and also Palestinian narrative about what's going on in Gaza. And he could have said nothing beyond, I'm dismissing the case on the grounds of the political question doctrine, but from the excerpts I saw on social media, he said even more in light of the ICJ case that it's plausible that Israel is committing genocide. And again, we might see more legal mobilizations, litigation, whether the UK or the US of this sort, trying to hold domestic officials accountable for their foreign policy decisions that involve them in grave violations of human rights.
Thank you. Okay, we're going to take one or two more questions from the hands that were up over this side of the room. Sorry, the lady in the pink jacket.
Yes, thank you very much. I was very struck by your comments that now it's up to the states and civil society to use the ruling to good effect. Now, if I can just make a digression, it's very clear that the UK government, and we're talking about the British Palestinian Committee, is not going to implement it. Within days, they supported the defunding of UNRWA, so starvation by other means. Right, so that raises the question, if the state is going to do nothing, what can civil society do under conditions where the British state is agreeing the export of arms and material to Israel? This poses the question of blockading arms production, stopping arms production, and stopping the transportation. So, I want to raise that with you and your opinion.
Thank you. There's another question here. Sorry, yeah.
Yeah, I echo the question. At the end of the day, politics, it's just the constant algorithm is that war is economy. So it's on the legal front, you're constantly tapping these complex layered narratives, but ultimately, the weapon companies calling themselves defense companies. Of course, if a government is complicit, the UK is not complicit in this instance, and surely these defense companies, because as you stated, there is no self-defensive, there's no attack on Israel. And then, of course, the banks who provide the financing, and then, of course, the media entities who are fueling the narratives that are feeding these distorted truths and the gaslighting on the cultural level, the pathology, some psychopathy of these deranged criminals. So I guess the question here is, when are we, right? I mean, I guess taking money out of the banking system is what we need to be thinking about on the ground level. But when will the fingers point back at the corporations? Because we're just going to keep seeing this repeating generation to generation, and that's where it's rooting from.
I'll take this one more here at the end. And the one at the back. We'll take two more because that seems like a similar set of questions. Sorry, Jen, that's the here then.
As you know, hundreds of people are being killed every day. They're ignoring the special measures imposed by the ICJ. And the only way to stop the bloodshed, this barbarism, is for, as you've mentioned, a multinational, international coalition force to go in, and a protective force to protect and save the lives of Palestinians, and a no-fly zone, and other immediate measures that have been used in the past. In December, I think it was around December the 12th, 11th or 12th, the General Assembly, under Article 377A, I'm not an expert in this area, I just read briefly on it, they, in effect, superseded the US veto, and the General Assembly seized the matter themselves and stuck two fingers up at the US and said, and Guterres, I don't think this is a very rare thing that's been done. And he had a special meeting, and they decided that, yes, there was the international security and peace had been breached in the region and surrounding regions, but then they stopped there. They did. Now, were they waiting for the ICJ to make a decision? Did anybody know that the ICJ were going to be involved? They just simply stopped, because I think what people need to do, and talk about practically, what we can do practically, is to write to the General Assembly and say, look, you had this special meeting, and it was called, at the drop of a hat. He called it the next day, 2 days later, and you've done nothing. You've now got the ICJ ruling to help you. That's ammunition that you can use. Do something now to stop the killing. I think we all need to look at what we can do now to stop the bloodshed. We can have legal arguments and talk about jurisprudence of what's happening, but we need to do something now. And can you tell me what the interplay is between the ICJ and the General Assembly using Article 3?
Okay, we'll pause there because we've only got a couple of minutes to answer these questions. One thing I will say is this is obviously a panel of legal scholars speaking about the ICJ ruling. We do have a whole series of these roundtables. One will be on arms trade specifically, one on media specifically. So we really encourage you to come to those, and we'll deal with some of those topics in more detail. Okay, we've got about 2 minutes and people are starting to leave already. So the questions have just been asked. If there's anything you wanted to respond to, as sort of final.
On the GA, the General Assembly, unfortunately, the Security Council has the authority to determine whether there's been a threat to the peace, a breach of the peace, or an act of aggression in response to events that then invoke international peace and security measures. So while the General Assembly does have the power to basically impose a public outcry as to the failure of the council in failing to respond to what's happening in Gaza, they have very little weight in the international system as a whole with regard to imposing such measures. They rely upon the Security Council to do that. And that's in part because the United Nations Charter in the aftermath of World War II essentially imposed a veto power in the Council on 5 particular states. So the US, the UK, France, China and Russia all have the power of veto on those resolutions. And so there's been absolute stalemate at the Council because obviously the US is not going to permit for any such resolution to be passed. And this is an ongoing issue. It's part of the failure of the collective security system. It's failed for a long time. I think it's almost now, it's pretty much dead. So we are at a point in the international system where we have to start thinking seriously about what we're going to do about this and how we're going to resolve these issues. But unfortunately, the GA just doesn't have the mandate or the power.
So the point of the United.
So I'll just intervene briefly on corporations. I think the governments are going to have to do a genocide impact assessment now to work out, one, enabling, and second, prevention. We should focus on the enabling right now because of the situation on the ground. And I think we can't rely on the government to do it and to operationalize such an assessment. So I think we, civil society, we need to do an assessment and targeting, as you mentioned, weapons companies and related bulldozers, I'm thinking of, and other kinds of companies, communications and finance, looking at their supply chains as well, because they get electricity from another company down the road, and they're also enabling in keeping that company going with knowledge that that company is sending weapons out. So I think with a massive impact assessment of all the corporations and anyone else who's involved on the ground through political cover and political support, and put all that information together and start pressurizing those companies and getting ITV to make a mini series so that the rest of the country stands up and does something about it too.
That's a very practical recommendation. Okay, well, we're gonna stop there because we're at 7 o'clock. But thank you so much to all of our panelists. I think you've been brilliant, and thank you also to SOAS and ISCI for co-sponsoring. If you want to be kept informed on any future events or any of the work of the British Palestinian Committee, then please go to our website and subscribe to the mailing list. We're at britpalcommittee.co.uk, or one word, or Twitter, Instagram, the usual places. Thank you very much for coming. Thank you all for
Algeria initiated the debate in the General Assembly.
I wanted to ask, you've lived together for too long. Yeah. That's a new person. Yeah. Eventually. The other one is thank you. It is interesting, isn't it? It makes you think. Situation, just like most time. Very amateur.
The US have been as is that be able to say, oh, we actually if I think do something.
Should do, they should.
I was
yeah.
Yes, that's what you can be like. You can be. It's been all time to be both. But I would imagine